The Supreme Court is about to decide whether to uphold a billion-dollar lawsuit against Atlanta's own Cox Communications for allowing users to pirate content. Back in 2019, a federal jury trial was held between Cox Communications and Sony Music Entertainment after claims arose that Cox was willingly allowing its users to illegally download thousands of copyrighted songs. Sony and other labels in the lawsuit didn't sue the individual users for piracy, for theft.
If you had to go after the individual users,
we would be without scalable, functional recourse.
Instead, they sued Cox under the theory of secondary liability. This means that Sony and the other labels argued that Cox continued to provide internet access even after receiving notice that certain users were infringing on copyrighted works. So the question for the jury was, should an ISP, an internet service provider like Cox, be financially liable for what its customers do online, especially when the ISP isn't directly distributing the stolen content? The jury found that Cox was liable for vicariously infringing upon 10,000 copyrighted works that were owned by Sony and the other plaintiffs. The verdict translated to more than $1 billion in damages. After the jury verdict, Cox appealed, and in February of 2024, the United States Court of Appeals issued a mixed ruling. It rejected the claim of vicarious liability, but it affirmed the jury's verdict that Cox was liable for willfully contributing to the infringement. Now, the Supreme Court heard these arguments just a few weeks ago, back on December 1st, and will issue a decision by June of this year.